This is a brief explanation about the meaning of no win, no fee. Where you've been involved in an accident and you've suffered injury, you're entitled to bring a claim. That claim can be funded on various forms, one of which is a no win, no fee arrangement. What is meant by no win, no fee is, as it explains, if you don't win, you don't pay. But that is actually in relation to the solicitor's fees. A no win, no fee arrangement is more formally known as a conditional fee agreement. It's a contract between you and your solicitor that your solicitor will run that claim on the understanding that if your claim is unsuccessful, he or she will not charge you for the time that they've spent in running the claim for you. You must, however, appreciate that that does not mean that you won't necessarily have some liability. Normally, on a no win, no fee arrangement, you are still liable to pay, or rather to reimburse your solicitor with regard to any disbursements that have been incurred. For example, applying for medical records or obtaining medical reports. It is therefore very important, if you do enter into an arrangement with your solicitor to fund a claim on a no win, no fee basis, that you carefully read the agreement. You must fully understand exactly what your liabilities are, just on the off chance that the claim is not successful and you are going to then have to repay your solicitor something towards the expenses that have been incurred. Where a solicitor is running a claim on a no win, no fee basis, under the rules that applied prior to April this year, your solicitor could recover from the fault party's insurers something called a success fee, which compensated the solicitor for having taken the risk in running that claim on a no win, no fee basis. There were various rules that governed the amount of the success fee, but generally speaking that was not something which you as a claimant would ever have to pay because your claim had been successful. The rules, however, changed as from the 1st of April 2013. The government brought in to the claims process a number of changes, one of which was to prevent the recoverability of success fees from the losing party's insurers. What they did in place of that is bring in the ability for the solicitor to recover from you a payment represented by a percentage of your damages. That is limited to 25% of the value of your claim. You will have that personal liability if you enter into that type of arrangement, and your solicitor will deduct that percentage before you receive the money. The level of the percentage to be deducted is something which you can agree and discuss with your solicitor. It is therefore again important, when you are looking at any such agreement, that you carefully read the terms and conditions and that you discuss in detail with your solicitor what the risks of that case are, and come to some arrangement as to what percentage ought to apply to your case, so that it is a fair and reasonable fee for you to pay, bearing in mind the complexities and the risks of that particular case. At the time the solicitor takes instructions from you, he or she should fully advise you as to the terms of any funding arrangement and the manner in which your claim is going to be run. The solicitor should also investigate with you what other potential methods of funding are available. Whilst everybody, due to press advertisement and otherwise, is fully aware of the fact that no win, no fee arrangements are available, a lot of claimants don't actually realise that they may have alternative funding methods available. One such method of funding is what's called a legal expense insurance policy, which is often attached to household policies and your car motor policies. Under those insurance agreements, you may have a policy of insurance which covers you for running a claim and will indemnify you in relation to solicitors' fees. Under union membership, you can also receive indemnity from the union to run any litigation on your behalf. The benefit to you as a claimant is that quite often, if you are funding a claim with that insurance or union cover, you would not have to pay any percentage out of your damages, and therefore financially you may be better off at the end of the claim. It is therefore important that when you do instruct a solicitor, you discuss all funding methods that are available, explore the potential for alternative funding other than no win, no fee, and then arrive at a decision with your solicitor on the best method of funding for your particular case with the risks involved.